Welcome back to this final segment in this law session dealing with how you approach exam questions in Common Law Reasoning Institutions, or ELS. Now, in the previous segments, of course, we looked at the beginning at a general approach, and subsequently in the second and third segments, we looked at specific questions, and I sort of showed you how you would approach those. Now we will follow in the same vein in this final segment and of course look at a particular question. Now we are going to consider an essay question on the civil justice system. Specifically, we are going to return to the University of London's past exam papers for their international programs, and we will look at question 2 from the 2011 paper, which was a question in relation to ADR, alternative dispute resolution. Now, the question said, provided that only suitable cases are dealt with informally, again, provided that only suitable cases are dealt with informally, alternative dispute resolution has an important role to play in the civil justice system. Discuss. So provided that only suitable cases are dealt with informally, alternative dispute resolution has an important role to play in the civil justice system. Discuss. Now, when you look at that question, before I get into the meat of it, what I want you to bear in mind is that by and large, most exam papers for common law reasoning, or indeed the English legal system, will have certain staple, precisely because of the nature of the beast, because of the nature of that area of law. So you will of course generally have something to do with precedent is on there, something to do with statutory interpretation is on there, something to do with the criminal justice system has to be on there, and something to do with the civil justice system is on there. Now remember, when this question came out, there was a student who, for all intents and purposes, came out of the exam and contacted me and said they didn't have anything to do with civil justice system, and I was thinking that's odd, because generally you would need this on a paper. But in any event, when it came out, the idea that it said ADR and didn't mention Wolf reforms or Wolf or anything like that seemed to have evaded him. Equally, it didn't seem that he had picked up on the last 3 words in the question, civil justice system. Rather, he just saw the ADR and ran with it, as it were. So when you look at a question like this, going back to the question, I want you to consider that there are some buzzwords, and look at the buzzwords and phrases within that question. Suitable cases, dealt with informally, alternative dispute resolution. Now, I will go back and preach to you and say, as a forever reminder, do not write everything you know on the Wolf reforms. Do not take an approach like that to answering questions. If you had prepared well for this area, then you would have had your notes on, for example, what this area involved. What were the issues pre-Wolf? What were the issues post-Wolf? Meaning, what were the things that Lord Wolf was concerned with before the implementation, for example, of his reforms? His concerns involved a system that was pretty much lethargic, it was expensive, it had extraordinary delays, he considered the costs were extraordinary, and he looked at what were the root causes. And one of the things, of course, that he thought was this advent and thought was fantastic was pushing or diverting more cases for alternative dispute resolution. Now, of course, he's had severe criticism from persons like Michael Zander, and certainly we see less harsh but nonetheless criticism from Hazel Gen. Now, Hazel Gen has done an extraordinary amount of work when you look, for example, at ADR. She's given a lot of talks in this area. She's written a fair bit on this area. You need to know what her criticisms are and what she said, because by and large, for me anyway, Hazel Gen's approach tends to be fairly balanced. I am not so sure about Michael Zander. I get the feeling, and this is my personal view, I get the feeling that Zander feels somewhat aggrieved that Lord Woolf did not do his homework properly. And so even when he wrote in 99, he wrote an article in 1999 in the New Law Journal, and then he wrote again in 2009 in the same journal, and he sort of said, well, I'm still not convinced. There are a couple of things that, yes, they're okay, and actually ADR was one of them. He said a couple of things are okay, but by and large, frankly, it could have remained the same. So what you need to be aware of in this area, you need to know what the criticisms are, what the commentators say, and if you are doing your preparation, you must make notes, right? So you would have had your notes. So when you look at the case, the question, what does the question mean by suitable cases? So you would need to consider the way ADR was advanced in the Woolf reforms, for example, and the question required you to assess alternative dispute resolution within the context of the Woolf reforms, and also required you to consider what are the strengths of ADR, and when you look at the strengths of ADR against the backdrop of the formal court-based dispute resolution framework. Now, the way the question is phrased, provided that only suitable cases are dealt with informally, ADR has an important role to play. When you start off with the beginning part of it, suitable cases dealt with informally, it is not a statement that you would disagree with. So it's not saying, well, as long as you have suitable cases that can be dealt with informally, you're not going to say no because it makes sense. So in starting your answer, you would broadly agree with that initial statement. Now, those disputes that can be dealt with effectively by ADR are, of course, probably best diverted from the courts. So you need to consider the cases, for example, where parties would still be in a relationship even after the dispute. Might those be, for example, amenable to ADR? So when you look at, for example, employment cases, family law cases, certain types of commercial cases, you could, of course, even when you look at personal injury cases, I mean, it's not a stretch of the imagination, even though the parties are not in a relationship afterwards, as it may be. But generally, if you look at a rule of thumb to look at, well, alternative dispute resolution, where you're looking at come to some kind of agreeable solution with the parties being involved, you could also consider what is the basis for ADR, because it is about giving the parties that say, as it were, as opposed to that adversarial nature of the formal court structure. So you could then show that diverting these types of cases for ADR would then allow for more efficient use of resources in civil justice. That said, though, please bear in mind what Michael Zonder's criticism is, because he's saying you can make a suggestion like this, but the reality is that when you look at it, it does not reduce any pressure on the formal court system, because advancing this as some kind of solution is to misunderstand the reasons behind why the court system was the way it was. Equally, when you look at Hazel Gen, she gives you some interesting statistics which show, in fact, if you were, depending on how you are reading the statistics, it actually seems as if ADR was better pre-Woolf, but that, of course, may not have been an accurate picture. Again, please bear in mind, reading of statistics can be fairly difficult. But when you look at Hazel Gen's statistics, it gives you a higher percentage, for example, of failure in ADR. But could that be because you now have a higher number, for example? So you would have to also consider unsuitable cases, because you do get the criticism that persons actually just use the ADR system so as not to be penalized later on. And that, of course, would go to your argument to suggest that suitable cases to be dealt with informally is what would be necessary. And then you frame that back in the context of the question. So you could start off by saying, for example, and again, I'm only giving you examples as to how you could start. So you could start somewhere along the lines of saying, In his Access to Justice report, Lord Woolf considered that one of the factors which adversely affected the efficiency of the civil justice system was the sheer volume of cases to be determined in the formal court proceedings. As such, one of his primary suggestions for reform was an overhaul that would involve certain types of cases which were amenable to alternative dispute resolution to be diverted from the formal court regime and dealt with in a manner more suitable to those types of cases. So you could start off by setting the framework, not disagreeing with the statement, and then setting a basis to build on for paragraphs 2, 3, 4, and so on. Now, from that kind of introduction, you would then want to highlight that although ADR has its strengths, it does have its shortcomings as well, and then you would want to then highlight that certain disputes can only be effectively and fairly resolved by formal court proceedings. Now, there's also an important issue to discuss in relation to the HRA. Specifically, you would need to consider what the issues have been and what the commentators have said in respect of Article 6, which is the right of a fair trial. And the idea of a right of a fair trial, of course, includes a person's right to insist on his matter being ventilated in the courts. So clearly, insisting on ADR for unsuitable cases might amount to a breach of Article 6. And so, of course, it takes you back to the question and the suitability of cases which can be considered informally. Of course, this is not to detract from the assertion that ADR can contribute successfully to civil justice by dealing with those cases for which it is suited in terms of informal resolution of those cases. So you would, of course, want to raise the important issues, but you stay on the point and answer the question that the examiner asks you. What you would not want to do, of course, is to just give a general, descriptive layout of either the Woolf reforms or ADR, as this would certainly not have answered the question that you've been asked. Again, if you are signed up to our premium service, contact us to request a copy of a sample answer to this specific question, which was genuinely written under time conditions of 35 minutes. And this, of course, brings us to the end of this law session dealing with answering exam questions on any common law, reason and institutions paper, or indeed your English legal systems paper.